But let's start with the judge, the Trump appointed judge in his first term, right, that blocked the deployment of the National Guard to Oregon. This Supreme Court has a new term coming up. I know it's a temporary blockage to the National Guard in Portland. How do you see this playing out? And can you kind of describe what happened and what's next for this case?
Well, if I were these reporters, I would certainly report that she's a Trump appointed judge.
Mhm.
But I actually know her name is Karen Immergut. I actually know her.
Okay.
She's another graduate of the U.S. Attorney's Office here in Los Angeles, pretty much the era that I was, a little bit after the era that Adam Schiff was. And she's just a very distinguished, brilliant lawyer. She went up to Portland, and I think she was the U.S. attorney there. And then I think she also worked in the state government. And of course, Oregon is two Democratic senators. If in his first term, Trump was going to appoint anybody up there, get anyone through, with the system that they have, Kim, she was certainly much more palatable than some really Trumpy judge. But she is a very distinguished, very serious judge. And so I do chuckle a little bit. Yes, she is a Trump appointed judge, but she's not the model of some of these, cuckoo birds that are sitting on some
Yeah,
of these circuits.
sure.
So she gets this case, and it's a very serious case because he's trying to call out the National Guard. And we had this issue down in Southern California. Does there really have to be an emergency? What if there really is no emergency? As there really was not an emergency. There was one night that things got a little out of hand, and the LAPD and the local officials here would have gotten them right back in hand, did get them right back in hand.
Sure.
This was a manufactured situation that Trump was just waiting for an excuse to send the troops in here because that's what he wanted to do. And, the courts get hung up on things like that because they are supposed to defer to the president. Who's to say how great an emergency it is? You don't want something like, after Rodney King verdicts in state court where all the officers were acquitted. And we really did have riots. I mean, but certainly there has to be some way, Kim, for the courts to determine that was a real riot, and anyone would tell you so. There was acrid smoke all over. Things were burning all over town, not in one area, not one night, but night after night, burning all over town, it turned out. And, we had an absolute riot situation. I still remember the tank was sitting in front of the federal courthouse, and people knew right, left, or center that tank needed to be there. How do you distinguish that if you're a judge from what's going on in LA, let's say? And that issue got bounced around in the trial court, which ended up being in the Bay Area. That was being heard about the troops that were being brought into Los Angeles, and it went to the Ninth Circuit, and the Ninth Circuit allowed it to pretty much continue. And now we're down to about 100 troops here. Nothing ever really much happened with the National Guard, and the Marines pretty much got withdrawn. So what does she do with this case up in Oregon, where there seems to have been nothing? I mean, not even a night that things got out of hand. There are demonstrations at the ICE office. That's understandable. People don't like the actions of ICE, and they're peacefully protesting in Portland. And this is another manufactured situation. So she gets the case and she says, you know what? I've examined it. I have evaluated it. There has to be some measure. I'm deferring to the president. Even so, there's no there. There's no here to call out the troops, and therefore the National Guard. I'm not allowing it. Trump decided to then go around her order, and instead of appealing it, even trying to get an emergency, an emergency order from the Ninth Circuit, which, as I say, had with a certain panel been receptive to the case that came from LA about the call out of the National Guard and the Marines down here in LA. Rather than go to the Ninth Circuit, Trump said, you know what I'll do? I've already federalized the National Guard in California. Why don't I send the California National Guard up into Oregon? And now there's even talk about, or maybe they have actually talked about sending federal deputized National Guard from Texas into Oregon. Now, if you do something like that, we really are on the verge of a civil war. People say that
the Texas National Guard has landed in Illinois. So
the idea of them going into Illinois, California, Oregon from Texas, and then what? When the Democrats get back in, we have so many tax cheats who don't pay their taxes down in Texas. We start to go after every good old boy with the IRS agents and federal troops and send the California National Guard in to roust and harass all of these Texas non-taxpayers. Can you imagine it? There's no end to it. And it really does become like a civil war, and states don't like each other, and you worry about hostile troops. In America, we have two huge oceans, right? We have friendly Mexico and Canada. We're going to start having hostile troops come into places like Oregon and California because they're from Texas or Mississippi. So she has now, I think, for the moment, stopped all of this. I think where things stand right now, Judge Immergut has not allowed any of this. And if they can't produce some new facts, like a real change in a situation like there really is a riot instead of just peaceful protests, or they get some ruling from the Ninth Circuit or take it up to the U.S. Supreme Court, I think things stand, and it's great for the rule of law that here is a courageous judge doing her job as set out in the Constitution, and we have a separation of powers, and she's saying, no, you may be the president, but you're not a king. No, the law prevents you from doing this, and you must not do this.
Before I turn it back over to Mark.
The Supreme Court, can you hear me? No?
We can hear you. Go ahead.
The Supreme Court seems inclined, as you were just kind of alluding to, David, to defer to the president and what the president wants. I mean, I hate in handicapping that. Do you feel as though the Supreme Court may give the devil his due here and let Trump just go after various cities with control over this National Guard gang to kind of move them around like chess pieces?
Until there's some precedent from the U.S. Supreme Court, Mark, that I think delineates some test for what should happen in all the states, I think for now it's going to be piecemeal, and it'll go state by state. I think the U.S. Supreme Court will stay away from some of these orders on the emergency docket. Like I think this Oregon one, I just don't think this is teed up for the Supreme Court because nothing is happening in Oregon. There are peaceful protests. You know, people hark back to the way it was when I was on with Kim during the first, the Trump administration, when things really did seem like they were getting out of hand in Portland. And they were at the federal courthouse, not only day after day, but night after night. And it seemed like the Portland authorities were sort of enjoying that, you know, like in your face, Trump, and not reining it in ways that I think prudently they should have reined it in. But that's not happening here. That's what Trump and some of Trump's base remember, that there was this sort of free-for-all, never-ending night protests in Portland. That's not what's happening now. And so I just don't think there's any record that's going to support overturning the order and saying that basically the president can send in troops anytime the president wants. And it's clear, the Supreme Court's not stupid. It's clear that he's just waiting, like in Washington, D.C. He waited for some young aide to be out at 3 o'clock in the morning. I think we all talked about it. Nothing really good happens at 3 o'clock in the morning. And I don't know what, they tried to carjack his car. And that alone was Trump's pretext to go into Washington, D.C.
Well, that brings me to my point, David, which is that they could use anything whatsoever, even a false flag of their own concoction to make the case like, yep, you see, we're going in. And it's clearly their desire. So I guess I'm just trying to, that they're reverse engineering it just the way I am logically.
Well, Mark, the courts have been slower than Trump, and Trump, by being, so impetuous, and it's not just impetuous, it's a strategy of impetuosity. And he knows that the courts, as a chess move, he knows that he can move a lot faster than the courts can counter move. But you look at this time around, first of all, a lot of these states have lawyered up. They've gotten very good lawyers. They've gotten more lawyers. They've gotten sort of ready for Trump's depredations. And they're moving faster. You notice this Judge Immergut up in the District of Oregon, she moved really fast. She issued an order over the weekend to stop what he was planning to do, I guess, on Sunday or Monday. And she's followed up and she's issued orders quickly that he would be in contempt if he violates. That didn't quite happen with some of the earlier Trump litigation. In Illinois, I think they're already presenting this litigation. I think right now, today, they were arguing in Chicago about this. I don't know what the ruling was, but I saw about an hour ago they were arguing it still in court at that moment. And when they go into some of these other, he's backed off from going into New York City. It doesn't look like he'll go into New York City. So I think that the one that gets to the Supreme Court brought by Trump will be one with a much better record than there is in Illinois or Oregon. I think he'll wait for something that really does look more like a riot. And of course, it's just a matter of time because he's so provocative. Part of what he does is he taunts the local populace to do something, and then he uses what he's now taunted to have happen as his, what's it, causa belli, his cause for war, his cause for invasion. And so there's this awful symbiosis that he's playing. But I don't think he's going to go to the Supreme Court until he has one with a better record than Oregon or Illinois.
I mean, the back and forth that's being played out, that's got a virality now on media, is the Stephen Miller conversation saying that the president has plenary authority and can, the sort of the suggestion, plenary authority, you can explain it legally, but essentially, he's in charge. He can do what he wants. But generally, it's thought of usually in a limited area, but the idea somehow, and it very much works with the unitary executive theory, is that no, he's in charge. He can do whatever he wants. That's the disposition of this administration, clearly. What's being, the pushback and what's being said is, and what's being said here by you is, no, the courts are going to push back on him and limit him in his desire to move all of these troops into these various places around America.
Yeah, I think that's exactly, they have a terrible disposition, and Stephen Miller and Trump himself have said right out loud that he's an authoritarian, that he wants to push people around. What did he say the other day? It was so extraordinary. It gets lost in all the outrages day after day. But he told the military, assembled 800 top generals and admirals, that they should use our cities, and the people of our cities, our citizens, should use them as a training ground for their military tactics. And that there was an internal enemy. And obviously the idea was that the Democrats and anyone who stands up and exercises their First Amendment rights is the enemy. I mean, just absolutely extraordinary. Mussolini, on his way to power, did not give speeches this authoritarian as Trump and Miller do. So is their heart totally in the wrong place? Is their head totally not what our democracy and our rule of law are all about? Yes. But I've said this for a while. The courts really are standing up. And of course, the wild card is the U.S. Supreme Court. But you got to take it, case by case. The U.S. Supreme Court term is starting. I know they did some bad things on the emergency docket. They'll do some bad things on the regular docket. They will, I think, reverse some of the things that they did on the emergency docket when they hear the cases on the merits. But yeah, he can get a lot of mileage from these speeches. They're also making him unpopular. And I've said that even on right-leaning networks, and not gotten a lot of pushback because they've seen the polls. Trump is incredibly unpopular. He's going to try to run on this law and order thing and push this authoritarianism as far as he can. But I still think it's going to be okay, Mark. I think that that bill here is going to win that initiative, allowing us to redistrict here. And there's actually an issue that in the Supreme Court there is some balloting, write-in ballots, and some not write-in ballots. Mail-in ballots. And some issues about that would affect the vote. I think when it all shakes out, I think the Democrats win the House, and that restores a lot of order with the oversight that could then occur.
Well, okay, maybe we're really counting on that. I mean, just to get back to the Supreme Court and the ballot thing that you're talking about, they are going to hear arguments about and around this lawsuit challenging mail-in ballots. The Supreme Court is saying that this would let candidates freely challenge state election laws. It has the potential to clear the way for a wave of legal challenges ahead of these midterm elections. And as you know, the president, and it seems as though, he's the conductor of the orchestra these days, he has very much spoken out against mail-in ballots. So during oral arguments in this lawsuit brought by Illinois Congressman Michael Bost, the justices appeared open to letting him contest this state law that allows the counting of mail-in ballots up to 14 days after voting ends, provided they were postmarked on or before Election Day. They're saying that, I think the lawsuit's saying, right, David, that shouldn't be allowed. I wonder if you can speak to that and how it might have an effect, a real-life effect on the election.
Well, the people who think that some of the U.S. Supreme Court justices, Alito, Thomas, some of those picked by Trump, that they really do not have justice in their hearts. I think they look at this case and they think, why on earth do they seem to want to make it so easy to challenge mail-in ballots? Why does the U.S. Supreme Court want to do that, including to give this one Congress member standing? Standing has always been very hard to get in these cases. If you and I say, they didn't count the vote right, and it came down to 5 votes in California, and we want to challenge this or we want to challenge that, they're pretty much going to say, no, we don't have standing. We were just hurt the way other people were hurt. We were hurt the way all voters are hurt. If we challenge our taxes, they say, no, you guys were just, or how they promulgated taxes, they say, no, you guys were just hurt by the tax code the way everyone's hurt by the tax code. You don't have that individualized, that particularized injury in fact that we're looking for to give somebody standing. And the whole idea of standing, by the way, is that people who don't have an injury in fact may have collusive lawsuits. They may not fight hard. They'll allow the issue to get decided on a collusive basis because they don't really care. They don't really have any injury in fact. And from that idea, which is, I think, pretty ethereal and abstract itself, we have all this standing law, and so many issues never get decided because nobody ever has standing, or you suddenly think a case is going to be decided that the whole country is watching, and then they dump it, there's no standing, and people think, what an off-ramp, what a cop-out. And so the fact that they've made standing so easy in this case is very perplexing unless they want to encourage a whole lot more ballot and mail-in challenges, because they've allowed a Congress member who wins by 75% of the vote.
Yeah, that's the guy who's bringing the lawsuit. Exactly. He's an odd guy to bring it.
He said, it's not enough that I win by 75%. I need to know whether I'm winning by 74 or 76. It's so important. It should change all these rules of standing that the average person just can't bring a lawsuit over mail-in ballots, but I can bring a lawsuit over mail-in ballots because it's so critical. And Alito says to the lawyer for, I guess it's the state of Illinois, anyway, whoever's arguing against this 75% ruby red Republican congressman argues against him. Well, wait a second. Why does it matter? And Alito said, well, isn't it obvious that the person who's getting the vote tally is hurt in fact when it's reported that they won 75%, when if the mail-in ballots had done differently, the person would have won by 76%, to which you say, that's the stupidest thing I ever heard from a U.S. Supreme Court justice. No, it doesn't make any difference at all. What the tally is, especially for this guy, the tally's not even decisive. Maybe the guy who's 50.1, right? But this guy seems so unlikely to have standing under normal law. It just seems like somehow the Supreme Court wants them, the majority of the Supreme Court seems to want to make it easy to challenge mail-in balloting, something that is the big hobby horse of Trump. So it looks like just another one where if it's Trump's hobby horse, his justices on the Supreme Court want to help Trump ride it.
That's why I say he's the conductor of the orchestra. And the other thing they're doing, it would seem, is that this redrawing of districts that could yield more House seats, a lot of experts are forecasting the end of the election law, which the Voting Rights Act, which would somehow, which might be the bulwark against that. And they are saying that the court may really undermine this piece of kind of a foundational legislation, or a foundational ruling, maybe is a better way to put it.
Well, this one is of great concern because even if California redistricts, and even if the other states realize that this war is not getting anywhere, Missouri then redistricts, New York then redistricts. So it's just decided that, after California, responded properly, fire with fire to what Trump and Texas tried to do, which was really a monstrosity that we have to address properly here in California. If everyone decides to stop fighting over this Voting Rights Act could still land a Republican safe House. And the reason is because the Voting Rights Act is very complicated, but it's been cut back. One of the most famous ones was the Shelby County vote. That was another one of the outrages of this Supreme Court, when they basically said there's no more racial discrimination in the South, so we don't need to have like pre-clearance of changes that have a racial impact, because that's all been taken care of. That's in our ancient history, and it's all kumbaya, and there is no discrimination against Black people anymore in the South, so we don't need to worry about it. And as soon as the U.S. Supreme Court said that in Shelby County, of course, a lot of these southern states went back to the same old Jim Crow-esque things that they did to suppress the Black vote. One reason they can't suppress the Black vote is because in the minority vote is because in the Voting Rights Act, what's still intact is these minority representation areas. And so if they were allowed to gerrymander in some of these states, they could gerrymander out just about all of the Black seats. And what stops them from doing that now is that would be in violation of the Voting Rights Act and would be racial discrimination that violates the Voting Rights Act. If it no longer violates the Voting Rights Act because the Supreme Court so decides this term, they could go through, let's say there's a black Congress member in Birmingham, Alabama, and there's another one in Montgomery, because those are two black areas of Alabama. They could gerrymander it in a way that there would be no black Congress members. The blacks would be only 35% everywhere. They would lose everywhere. And because the country is so polarized on race, especially the South, you would end up with only white Congress members from Alabama, whereas now there are two, and the Voting Rights Act wouldn't prevent that. That would tip a lot of those southern states, maybe 10, 15, 20 more members to white Republicans. They say that 30% of the members of the Congressional Black Caucus would be wiped out if they get rid of the Voting Rights Act, and if the southern states respond that way. That is a major, major thing that the U.S. Supreme Court could decide in this one case that's coming up this term. They could eliminate, by their ruling, 30% of the members of the Black Congressional Caucus. Big deal. As Biden used to say, big effing deal.
They could draw 19 more seats, and you may say, well, can't the blue states do the same thing, kind of the way California's answering Texas? Yeah, but as you just heard David say, you can redraw it, but you have fewer opportunities in blue states to redraw the way they can aggressively redraw in some of these other places to which David's referred. And at the end of all of that, having done the arithmetic, you get almost 20 seats that go to the GOP. So it's a pretty grim scenario. Now, my understanding is it likely won't be ruled upon by the Supreme Court before the midterms right now, but it also might be. Like they could fast track that, but from what I was understanding and reading, it likely wouldn't make a midterm deadline.
There's probably enough administrative things that a state would have to do. If they decide in September, you can't have the early November election done under a September, well, they don't sit in September. I mean, they have to decide all their cases by the end of June, Mark. So if they decided it in May or June, I guess the question would be state by state. Could a state actually redraw the line in that time? There'd be some, you don't know the decisions coming exactly. So would Congress members be ready to run for re-election? Would challengers come along? So you're probably right. In most states, it would not affect the midterms. But certainly it would be teed up to affect all of the elections in 2028 if the Supreme Court rules that way. Not entirely clear they're going to do that. This is a kind of, I think, too close to call. Although I want to say something about your ruling on the tariffs before I forget. Okay. Not only you and I agree to disagree on that, and guess who's on your side? The Economist and the Economist magazine's robot. They have actually thought it was worthwhile. This is so important, tariffs, free trade, to the Economist. There is an Economist bot, and the Economist bot agrees with you. Your Mr. Predicto may agree with you. I don't know, Mark. Looks like 3-1 against me. You, the Economist robot, and the and Mr. Predicto. So
where's my Economist? I subscribe to the Economist.
3-1.
We didn't ask Mr. Predicto. Let me just ask Mr. Predicto right now. Mr. Predicto, will the Supreme Court rule that the Trump tariffs are illegal? Will the Supreme Court rule that the Trump tariffs are illegal, Mr. Predicto? Let me just ask.
Definitely, yes.
Wow, that's one for you then, David Katz.
Okay.
Mr. Predicto thinks Mr. Predicto thinks SCOTUS will overrule the president's tariff on the tariff. Well, we'll see. I don't know.
Don't anybody bet on this. I'm sure you could. There's action on this, like there's action on anything. But do not go in there and say Mr. Predicto and Katz. Said what
but if you are keeping score, Mr. Predicto and Katz believe SCOTUS will rule to overthrow the tariffs. I believe
take Mark Thompson and the smart money with the Economist.
All right, now let me ask you quickly about James Comey. Surprisingly, he pled not guilty.
What?
This is a clown show of the first order. I mean, this is the crew that brought the case. insurance lawyer leading things, got rid of the last guy who was a Republican, died in the wool GOP guy. She's, as I say, an insurance lawyer, never tried a case before, didn't have even the case laid out in any kind of a reasonable fashion. Apparently, like all the I's weren't dotted and T's weren't crossed, quite literally. It's this slapdash team of legal assistants who have kind of show up in court. I mean, it's really a bad look, but Trump just wants to play the moment. Comey, in my judgment, Comey charged, Comey has to plea, Comey has to do all that humiliating stuff that Donald Trump, had to do also.
Yeah, that's a very large part of it. It's pure revenge. It's pure that, and it's not the fact that the cases were righteous against Trump, that they were well researched, that the law and the facts supported them. You know, like every bully, you know, he just wants to have his way. He never stops to think, you know what? Maybe I should step back and say they had good cause. I was very lucky. Things worked out my way. The U.S. Supreme Court worked out my way. A lot of things worked out my way. 6 justices on the U.S. Supreme Court were the main thing that worked out my way. And I was fortunate. Why don't we rule the country? You know, why don't we govern the country in a rational way? Why don't I be remembered in history by something other than being a vengeful little bully? Well, he wants to be a vengeful little bully. That's really what makes him tick. And that's what he's doing right here. Now, the Comey thing is a really interesting situation. You know, Mark, this is what I am. I'm a federal criminal defense attorney. Never represented a former FBI director. Obviously, no former FBI director has ever been charged or, so far as I know, criminally investigated. But there's a 70-day speedy trial act. And he could force this case to go to trial in 70 days, whether the government is ready to go, whether they've done things within that timeline that they have to do. That would be held against them. Like if they can't produce discovery to him, that would be a discovery violation. And if they kept saying, we need more time, we need more time. A couple of things. First of all, don't indict a case if you're not ready to meet your discovery and all of your other obligations. Well, we wanted to meet the statute of limitations. Well, start earlier. I mean, you got to remember, if they were going to have this vendetta against Comey, it didn't just happen the day before. You know, if they were going to do this vendetta, they were going to do this vendetta probably since November. That's been their plan. They need to prepare. So it would not be, the government would not be heard to defend itself. In other words, a judge would not accept the argument that they weren't ready. One of Comey's things is if he really wants to push the case to trial within 70 days, though, and take advantage of probably all the discovery lapses and all the things that the government's done wrong procedurally, he's got to make a motion. And if you make a motion, you stop the clock. So this Speedy Trial Act clock that runs for 70 days, while motions are pending, it stops. So if he makes his motion to dismiss for vindictive prosecution or for selective prosecution, they're slightly different, or for the grand jury abuse, or for the mistakes that were made in how it was presented technically. So the case should be dismissed technically, because technically the indictment's not correctly worded or correctly signed. He's got to stop the clock. And I think that's one of the things that his very good lawyers are deciding what to do. And it may be that I think at the end of the day, I said this last week, nobody really wants to go to trial. I mean, you know, there could be 2 jurors who find him guilty, even a hung jury. You imagine how Trump would trumpet that if any one of the members of the jury. And then they started with Washington, D.C. It was so biased against me, Trump. But even the biased D.C., you know, voted him guilty. All you'd hear about is the 2 or 3 people who voted him guilty, not about the 9 or 10. Then they get to have a retrial of Comey. So I think Comey and his lawyers have to think all of that through. And on balance, they file the motions. They stop the clock and they file the motions that he was selectively prosecuted. That's, I think, very, very clear from the record. And this whole public thing, we talked about this last week, but I think it bears repeating again. If all he wanted to do, Trump, was to get one particular enemy indicted, and that's very scary under the Constitution. That's very scary under the rule of law. But how would a really, forceful president, how would LBJ, let's say, have done that? LBJ would have, or take the worst case scenario, take Kennedy. How would Kennedy have gotten his brother, the attorney general, to have indicted somebody that was a political enemy of Kennedy? And there's no evidence that this ever happened. This is purely a hypothetical. He'd whisper in Bobby's ear, and Bobby would indict that person. There'd be no record. What would you show that it was vindictive or that's not what happened here. What happened here was that Trump sent, right, a tweet or an X out to the world so that tens of millions of people, the whole world, would know that the reason Comey was getting indicted was not on account of the evidence, not on account of Bondi's discretion, but because he ordered it in capital letters in a public message. Indict this guy. Time is running out. Do it now. And the reason for that was intimidation. Let me just say this. Let me finish my point. The reason was intimidation. The reason was to show that I'll get you. Okay. I'll make it that public that I'll get you. And we've never really had kind of a situation like that in the courts against such a high profile enemy. That may make new law. There may be something after this, which is not called selective prosecution, not called vindictive prosecution, but Comey-esque. And the combination of things, they just may say that just this sequence of events, if you can show that anything similar like that happened, then you'll get relief in the future. And why that's important is because he plans to have things like this happen in the future. He plans to have this happen to New York State Attorney General Letitia James. In his awful nightmarish fantasies, he imagines this happening to Senator Adam Schiff. And they will have, I think, after this case, a motion that they won't have to even fear prosecution. They will have a Comey motion, which will, I think, be able to pretty much quash these bad faith investigations or bad faith attempts to indict them.
Well, Kim was telling me that public proclamation that you described was actually intended to be a DM. Didn't you say that, Kim? You thought that that there was corroborative. You were talking to me about that earlier today. Mm-hmm. That I'd always heard that it was thought to have been a DM that ended up public. You know, the go after Comey, go after Schiff, time's running out, that one. But right. You were saying to me earlier that that it was essentially offered. There's increasing evidence offered to suggest that was supposed to be a DM.
Supposedly, according to sources, it's been confirmed that that was a mistake on the president's part, that his big Truth Social post about directly to Pam Bondi about all the people that she needs to go after and how it's making him look and how they need to get it done now was not intended for public consumption. It was supposed to be private to her.
Regardless, it wouldn't affect it legally, would it, David?
I don't think it would affect it legally. I mean, the people who are astonished by how incompetent Trump's people are, that would be just another, that would be like the one, right, the chat that
on like on the Signal chat,
the Yemenis before
it's
they
amazing that
the
they're
Yemenis.
Talking over public media anyway. It's crazy to me that everything, like, you know, official pronouncements of every sort are supposed to be on the X platform. Are you kidding? I mean, the whole thing is lunacy to me.
That's like the Durst thing, remember? The Durst case.
Sure.
What was that thing
the
called?
murder case. Yeah.
Where, he didn't know the thing is live, and so he says to the world, I mean, I guess that's, what was it? I killed, whatever.
Of course I did it, is what he said. Yeah.
This would be, of course I did it. This would be, wow, I meant to say this secretly, and I said it to the whole world. I mean, Trump, he seems to live everything down, but I've only said this for 7 years to Kim. Kim, you've heard this before. His luck will soon run out.
All right. So I wanted to ask you about something that to me is kind of bizarre and nothing to do with Comey, nothing to do with voting, etc. Nothing to do with Trump. It has to do with the real surge, I think, in a growing theocracy, I believe, that is taking a hold in America. But that's the broader question. The Supreme Court and legal question is about this conversion therapy. It's for minors, those who, they go into these conversion therapy programs because they're gay, they have gay instincts, etc., and their parents, their family exact some, psychological, I would think, effect on them to the point that they feel and they compel them to go into this conversion therapy. So there's a ban on this stuff, right? And in Colorado, you can't do that. You can't put your kid in conversion therapy. Now the Supreme Court is hearing a case about it, and the Supreme Court is inclined, from what I'm reading, to allow it, to overturn that law that's in Colorado banning it.
I won't even score a Katz on this because the argument was so clear that a majority of the U.S. Supreme Court is going to vote against Colorado. And the way that this comes about, and I don't know, you have some young listeners who may not really know about this, but the idea was that if you showed homosexual tendencies, you would be sent to a counselor, and they'd show you like pictures of beautiful women or something like that, and say, "See, you should be a heterosexual." And they would do, worse things than that. They would do all these therapeutic techniques, supposedly. And so these states, there's 27 states, they're predominantly the blue states, said, no, you cannot have this kind of conversion therapy because it's more than showing pictures of beautiful women.
Oh, they beat kids. They wrap them up in carpet and beat them with a. I mean, there's a physical violence part to all of this, at least historically, and recent history too.
Yeah, so a licensed in those 27 states and Colorado, a licensed therapist would lose their license if they engage in any of that conversion therapy, all the way from what you say physical assaults to talk therapy. Talk therapy that tries to talk somebody out of being a homosexual or out of wanting, let's say, a trans procedure, something like that. And so it's attacked on the argument that it's banning free speech. There's no friend of free speech, supposedly, more than the Trump administration and their officials and their lawyers. So isn't that a terrible violation of free speech by the licensed therapist that they would lose their license if they talked in that way? And the U.S. Supreme Court is going to say, yes, that would be a terrible violation of their free speech rights if the state stopped them by challenging their licensure by giving that sort of talk therapy. Of course, the other side of it is that it's treatment. It's not talk. It's not First Amendment. And that the states all ban kinds of treatment. There's loads of treatments that a doctor might think, a wacky doctor might want to give you, or an edgy therapist might want to give you, that are illegal. That the state, they don't allow you to, if you have an infection, they don't allow you to be bled, like in the Middle Ages. There's loads and loads of treatments that they don't allow to be given. And so the dissenters are going to say, this is more like treatment that the states have a right to regulate. The fact that there be some small element of talk in it is not the point. And the conservatives will win, and the majority of them will say that this is talk that is being suppressed and not allowed by the state.
It's outrageous. It's crazy. Like someone could talk you out of or beat you out of being a straight man, out of being
it's
hetero.
Awful.
It's crazy.
It's just awful.
Johnson & Johnson ordered to pay $966 million. This, again, is the Johnson & Johnson talc powder that I thought they'd ruled on this over and over again. They have tied this talcum powder to mesothelioma, and this is this rare cancer, but there has been an absolute connection between this Johnson & Johnson product and the family of this California woman who died from this rare and aggressive cancer. They won the lawsuit, and now an LA jury is ordering them, Johnson & Johnson, to pay that almost $1 billion to the family.
Well, there's an attorney in Los Angeles. His name is Bart Williams, and he's represented Johnson & Johnson for years. Actually had some successes, but it looks like the days of Johnson & Johnson winning these talc cases is really coming to an end. They've actually tried to go to the bankruptcy court several times, the way that who are the people with the opioid?
Like the Rudy Giuliani move?
Yeah. Well, no, more like the opioid people. Remember the opioid people, that family?
The Sackler family?
Yes, the Sackler family. They've tried to see if they could, resolve this in bankruptcy. Johnson & Johnson has done that little trick where they have a subsidiary, and the subsidiary goes bankrupt with all the bad claims, and they try to save the company that doesn't go bankrupt. I think Johnson & Johnson has pretty much stopped marketing the talc. Check me on that. Because it's generated so many lawsuits. What's going to happen to this particular judgment for $960 million? This is for one plaintiff who died, and she got, I think, about 40 or 50 million in compensatory damages, maybe less, but over $900 million is punitive damages. I think the U.S. Supreme Court, if it goes that far, will overturn that, whether people like that or not. That's considered cruel and unusual punishment or excessive fines. Barred by the 8th Amendment. And when there's a huge disproportion between the compensatory damages and then the punitive damages, they cut back the punitive damages. So no, either the trial judge or some appellate court will not let the plaintiffs and their lawyers walk away with over $900 million, but they will get a big chunk of change. And there's loads of these plaintiffs around. The argument is that there's asbestos in with the talc. Johnson & Johnson's side of it is that no, they separate it out, that they have purity procedures. But there are some internal memos that the plaintiff's bar has managed to get out of Johnson & Johnson over the years, dating back to 1971, and expressing in these internal memos, Mark, concern that there was indeed a great deal of asbestos and asbestos exposure.
That's the thing. It's asbestos. Exactly. Right. Yeah. It reminds me, the verdict and the judgment, of a movie that I know you saw, because I can't imagine someone who is steeped in the law as you are would not have seen it. And that is the Paul Newman movie, The Verdict. Yeah. So in The Verdict, spoiler alert, I think it came out in the 80s, he plays this lawyer, and it's a great role. He won the Academy Award for it, I think. So, but they get to the case, and it's everybody, with the expert witnesses and, everybody. And then they find this surprise witness, this nurse who's reluctant, who wants to testify, and she does testify. And of course, it's damning, and these big, bad corporate, think Johnson & Johnson kind of people are finally. It was a malpractice case, though, but the equivalent with this doctor in this group. And the jury comes in, and they rule for Paul Newman and his client, and against this horrible doctor who covered up, the bad thing that he did, et cetera. But this is the part that I know you'll remember, and it made me think of it when I saw this judgment of close to $1 billion against Johnson & Johnson. The judge asks, "Is this your verdict?" And the foreman says yes. And then the foreman says, "Are we limited, Your Honor, in the penalty that we can apply to the doctor?" And, there's that moment. I'm sure it's just a movie moment, but it's really great, because the judge goes, no, you're not limited to the, to 17 million. In that case, Your Honor, we believe that the defendant should pay $100 million, or whatever it was. It was like this. Oh, the damning of a guilty verdict was actually doubled by the damning of the judgment, the civil case, as it went. So it reminded me of this with the Johnson & Johnson thing, because the amount of money is so immense that it suggests that there was real, you guys knew that this stuff was causing cancer, and you still allowed it to go out onto the market, and you even marketed it as safe.
Well, I read somewhere that they have a reserve of $7 billion, Johnson & Johnson does. And again, they're trying to somehow discharge all of these claims in bankruptcy and sort of emerge on the other end. But, at this rate, even if this gets cut back, it will get cut back, Mark. But let's say it gets cut back to $100 million. Okay, so how far does $7 billion take you if you have a bunch of $100 million judgments, if you have a bunch of $50 million judgments? And there's you can see the other side of it. Company, maybe some people don't see the other side of it, but at least companies that are doing, like Johnson & Johnson, if the entire company went down and all of its products went down with it, and there are some other very good products, there is an idea, and certainly the conservative U.S. Supreme Court has it, that it at some point does become an excessive fine. $1 billion verdict for one person, where 950 million of it, or 900 million of it, is punitive. The Supreme Court will strike this down, and people who, the Constitution does have this provision that excessive fines shall not be imposed, and I think that's a fairly good argument, just textually and so forth, that $1 billion punitive damage awards, even if there are internal memos, even if the jury comes away thinking, boy, do we want to punish these people. We do have the criminal law for that. If somebody knowingly puts a bad product on the market, the idea that no one should be, we kind of had this. We even had this under President Obama. He was very sharply criticized from the left for this. It seemed like no corporate executives ever got prosecuted. They had a deferred prosecution agreement. They paid a whole bunch of money if they were Johnson & Johnson. If there were some executives at Johnson & Johnson who knew about this, right? We may have an
executives never
excessive
pay a
fine.
price. The '08 executives, everybody, banking executives, Wall Street, they never pay a price. We all know that. And I'm getting the blowback now, David Katz. I need a lawyer now. Rick S.
Okay.
says, Mark likes giving away these movie endings. It was in the 80s, dude. If you haven't seen it, I mean, there's a statute of limitations on giving away endings. It's Paul Newman. What do you think he got? He got a verdict against him? He's the star of the movie. My God, this is
why he's down on his
all
luck.
right.
Isn't that the one where he's down on his luck? He's drinking
Yeah,
too
it's
much.
great. You should see it. It's got nothing to do with the. First of all, there's a great twist, and secondly, it's got nothing to do with the. You know what's going to happen. Somehow he's going to prevail, just the same way that somehow Superman always gets out of whatever. But I'm just saying that getting there, as you say, he's a down on his luck lawyer. He's drinker. It's really, it was one of his best roles. I think he won the Academy Award for it. So, all right, look, I love knocking around the schoolyard with you. Thank you for this, David Katz. We'll look for you on everything from News Nation to Fox News Channel to CBS television and radio. I don't see how you get any client work in with all this stuff you're doing.
I'm supposed to be doing News Nation on at 4:00 Eastern time. I guess that's 1:00. It's one of those times.
Look at everybody on the East Coast. Look for him at 4:00 and 1:00 on the West.
No, at 4:00 on the West Coast. 4:00 on the West Coast.
No,
and
okay.
that's on Saturday.
Okay.
And in terms of getting other work done, I'm a working lawyer, but I've always loved following the Supreme Court and what they call the advance sheets. And it's great to share them with you because this is I think it's fascinating. And you look at how much the fate of the nation depends on the rule of law, depends on what these courts do right now. And so to me, I love the baseball, I love the playoffs, but to me, this is fascinating and as
well and
as
wildly important.
About a greater impact. Talk about
wildly important. Yeah.
Your Honor, I'd like to ask for a recess.
Okay. All right, David. Thank you. Appreciate
My
you.
pleasure. Take care, guys.
The
Take
great
care,
David
Kim.
Katz, everybody. Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.